Hello, everyone. This is a first time for me to teach you remotely the law of IHL, and it's a pity that we have to do it like this. I do hope that you are coping with this situation, all of you, and that your family are well and that you are too. I have a special thought for those who are living away from their loved ones, that they are not with their friends and family in Bern and in Switzerland. So it's going to be fine. Let us wait for a couple of weeks and then we'll be able to discuss together the law of IHL. So today we are going to look at the law of non-international armed conflict, which is the regular course that we had to address for today. It's quite a pity for me not to be able to talk to you in person about this topic, which is really my favorite one. I do hope that this is going to be okay, and if you have any questions, please send me an email and I will address the question as best as I can. So the structure of the course is going to be the following. We are first going to look at the context, the definitions and the typology. What are armed groups? How can we evaluate what an armed group is? The second part of this course is going to be on the applicable legal framework. What is the law of IHL and human rights law applicable to armed groups in non-international armed conflicts? The third part of the course is going to be on how to engage armed non-state actors. Is it necessary? Is it feasible to engage those actors? And the fourth part of the course will be on the challenges that we are encountering today in non-international armed conflict with regards to armed groups in general and how to engage with them. So first of all, let's look at the context. In the first courses, we have seen how armed conflicts are classified. They are classified as international armed conflicts, including situation of occupation, and this is what we have looked at last week. And today it's going to be about the conflicts that can be classified as non-international armed conflicts, which is conflicts that oppose armed groups on the one hand and states on the other, or armed groups between themselves. In the War Report 2018, including in the Rule of Law in Armed Conflicts project, we have a series of situations that can be classified as non-international armed conflict. And for many years now, the majority of the conflicts are indeed NIACs, non-international armed conflicts. And this raises many challenges, as we will see. So the list is well known. We have looked at it the last time. So Afghanistan, Colombia, there are issues whether or not certain members of the FARC are still involved in a NIAC with the government. The DRC, there is a NIAC in Sinai, India, Iraq, Libya, Mali, Myanmar. This is a repetition of the slide. And then you have Nigeria, Pakistan, Philippines, Somalia, South Sudan, Syria, Thailand, Ukraine, and Yemen. Not all states accept that they are in a situation of a NIAC with these armed groups present. And part of the reasons for this is that they don't want to be considered as being involved with an armed groups, and also admitting that they are, or that they have lost control in certain cases over part of their territory. This is one of the reasons why they would deny the applicability of IHL to their situation. This is the case actually with regard to Mexico, which discuss the fact that there might be an armed conflict occurring in their territory. and also because they consider these armed groups to be terrorist armed groups, and states believe that they can take whatever measures are necessary to fight against these actors. Of course, this is not the case, as we have seen, because the classification of armed conflict is a question of fact and not a question of the perspective of the states, although the reality of the international legal systems and political system allows finally the state to decide which framework it wants to apply. And this is a problem because we are in an imperfect legal and political system where the recourse to the judicial review of a certain situation is not mandatory. So be that as it may, different scholars and organizations believe that in the list of the countries that I have showed you right now, there is a situation of non-international armed conflict. Now, let us look at what are armed non-state actors, because if we define that the law of non-international armed conflict is the one regulating, on the one hand, the situation occurring between, or the fight occurring between a state and a non-state armed group, it becomes very important to know what are armed non-state actors. And it is quite strange and curious that in international law, there is very few definitions of what are these actors. So in general, one has to look to other bodies of law, or rather other disciplines, in particular political science. If we look at the different definitions that you may find in certain texts, so for example, the UN Security Council has said that non-state actors are individual or entity not acting under the lawful authority of any state. Here, the UN Security Council has a broad definitions or approach of what is a non-state actor and does not focus on armed non-state actors or armed groups. The Kampala Convention also on internal displaced persons also talks about armed groups as dissident armed forces or other organized armed groups that are distinct from the armed forces of the state. So as we will see, the Kampala Convention also uses a definition which we may find, it's not really a definition, but a description of what armed non-state actors are in other treaties. But we will come back to this. Finally, the EU also has addressed the issue of armed non-state actors. And for the EU, those are actors that retain the potential to deploy arms for political, economic, and ideological objectives, which in practice are often translated into an open challenge to the authority of the state. So here it's also rather a large definition, but which is interesting because it also includes actors which might want to challenge the authority of the states for economic reasons and not only political ones. And it is also a reference to Max Weber approach to what is a state. And for Max Weber, the famous sociologist, a state is the entity which can legitimately uses force to maintain law and order. So an armed non-state actor would be some entity which illegally and illegitimately uses armed force against the state. When we look into international humanitarian law, we don't find much more information about this. So Article 1 of the second additional protocol, which, as you know, is the protocol which applies to non-international armed conflicts. And I would like you to have a look thoroughly to all of the provisions that you will find in additional protocol to regulating this kind of conflicts. So the protocol in Article 1 talks about dissident armed forces or other organized armed groups which, under responsible command, exercise such control over a part of its territory. And here you find at least three elements which are interesting. First, the notion of dissident armed forces, which are in opposition to the state. It also talked about organized armed groups, and we will see how to define the notion of organization. And it talks about responsible command. The definition of Article 1 of the second additional protocol is more restrictive than common Article 3. Why? Because it specifically addresses the let's say the condition that armed groups must control part of the territory. So for armed groups to be bound by Protocol Additional 2, they must control territory, which is not the case for common Article 3, as we will see. Case law has given some indication of what we can consider an organized armed group. You won't find in treaty law or in customary international law what are these, what we can consider as an organized armed group. And so the ICTY, the International Criminal Tribunal for Ex-Yugoslavia, has indeed elaborated some elements of indication that an armed group is sufficiently organized to be bound by IHL. Those are not cumulative conditions. They are only examples that will give you a sense of what an organized armed group is. The first element which is interesting to look at is the existence of a command structure and disciplinary rules and mechanisms within the group. The idea behind this is that a group, if it is bound by IHL, must be able to diffuse the orders to its own troops. You know, the fact that it needs to distinguish between the civilian population and military objectives, to devise sanctions if those principles are not respected. This is one of the first elements that is required for an armed groups to be considered as organized to be bound by IHL. Then you have the existence of headquarters, and can also, give you an idea of how organized is an armed group. As I said, the groups that controls a certain territory is also usually an organized armed group, although, as we just have seen, and we will look a bit more into detail, this condition is not required for common Article 3 to apply. We'll come back to this. The fact that an armed group has the possibility to access certain weapons, other military equipment, recruits, or give military trainings, its ability to plan, to coordinate, and to carry out military operations. For example, if an armed group has this possibility to conduct simultaneous military operations at a certain time, this is a good indication that the armed group is sufficiently organized to be bound by IHL. The possibility for an armed group to define a unified military strategy and to use military tactics, and its ability to speak with one voice. For example, to elaborate peace treaties and to negotiate ceasefire agreements. These are elements. All of these are elements that allow us to determine whether or not an armed group is sufficiently organized. Now, a last interesting definition of what can be an armed group, which I particularly uses in my own research is groups that operate primarily within state borders, because we will see that there are also armed groups which operate extraterritorially, that are engaged in violent attempts to challenge or reform the balance and structure of political and economic power, to avenge past injustices, and or to defend or control resources, territory, or institutions for the benefit of a particular ethnic or social groups. So Conciliation Resources here has devised an interesting definition of what is an organized armed group, or what is an armed group, which are these entities that are concerned by the law of non-international armed conflict. So, if we also try to look at more in details of how we can distinguish, or what are the elements to take into consideration when talking about non-state armed groups, is either elements such as, are they state, or do they have state elements versus non-state elements? This is not always easy, but this is one of the criteria that one can use, for example, to distinguish between a paramilitary militia that would act for the state, or proxy armed groups that are under the control of the state. And here the non-state armed group element which concerns us are independent organizations that do not act under the control of the state. Those are the ones that are concerned by the law of non-international armed conflict, and those are the ones that for which we can establish some kind of responsibility for their own acts. The second, element of the criteria to be able to distinguish what is an non-state organized armed group is, are they armed or non-armed? It's not always easy to determine what is armed versus non-armed, but a non-state actor is not always armed. One can think of an NGO, a non-governmental organization like Amnesty International. These are non-state entities and they are not armed. And of course, they cannot be considered as a non-state armed group under the law of NIAC. The other interesting element in how to consider a non-state armed group is this idea of a group and individual. The UN Security Council has, defined a non-state actor as being also an individual, because obviously an individual is a non-state actor. For example, one could think about the leader of a terrorist organization, like, now I have a blank of what could be a leader of a terrorist organization, but these individuals can be sanctioned at the UN Security Council as individual non-state actors, but they are not in themselves constituting of an organized armed group. So there is an issue of collectivity, right? The notion of territorial control is also an interesting one, because you can very much have organized armed groups that do not have territorial control, and they are organized rather as networks or cells. These entities are still bound by IHL, even if they don't have territorial control. They won't be bound at all by Protocol Additional 2, but they will be bound by Common Article 3 and Customary International Law, as we will see. And finally, there is this idea of ideology. Many people, when you ask them what is a non-state armed group, will tell you that, those are armed groups that fight for political reasons, that they want to be a secessionist movement, that they want to create their own territory. And it's true. I mean, most of these entities are of that kind. But today, the frontiers between why armed groups are fighting is becoming more and more blurred. Some armed groups want to have access to economical or natural resources. Some armed groups do trafficking of weapons, of drugs, just to finance their own operation. And some armed groups are just doing, drug deal. And in that sense, we cannot say that if an armed group like the Sinaloa cartel in Mexico does not have as an objective to replace the government, that doesn't mean in itself that it's not considered as an organized armed group in the sense of the law of international conflict. In terms of armed groups, you do have different types of structures or different level of organization. So under the law of armed conflict, what is required is to have a certain level of organization, but not necessarily to have the same level of organization for all the armed groups. So you will find some armed groups that have a high degree of organization, and they have a very strict command structure and hierarchy. And this you find, for example, the FARC. On the one hand, you can have the PKK as examples of this high degree of organization of armed groups, or the Tamil Tiger at the time of the Sri Lanka conflict. You also have armed groups which, as I just said, are organized in cells. So they are highly hierarchized, but the responsibility of the group per se is more difficult to establish because they are they diffuse their orders in a very confidential way and in a very undercover way, I would say. So they do not have very clear headquarters. They communicate in a very particular manner. So it will be more difficult to comprehend how this armed group works collectively. And then you have armed groups that are much looser in their structure, and at such a point that we don't know whether they can qualify as an armed group per se under IHL. And here I'm thinking about the vigilante armed groups, so the self-defense groups that organize. Those are individuals that organize themselves to defend against the violent act of other armed groups, either because there is a lack of authority, of state authority that would be enough to protect them against this violence. And here it's not always easy to evaluate whether or not these can be considered as non-state armed groups under international law. But again, case law and the interpretation of Common Article 3 and the Geneva Conventions tell us that what is required is a low degree of organization and not necessarily a very high and sophisticated one to be bound at least by Common Article 3. Here again, looking at rather political science terminology or approach, you will find indeed different types of armed non-state actors. All those types will rather be bound by IHL in the same way, but because we are also going to talk about how to engage armed non-state actors, which is one of the main policy goals of the international community today, it's also important to understand what are those armed groups in terms of the type, what they are fighting for, and how we can approach them with a certain legal discourse. So you'll have partially recognized states or quasi-states. Somaliland, for example, which is an entity which is not recognized by the international community, but very much function as a state. You have armed opposition groups. The majority of armed groups today, as I told you, I gave you some examples. The SPLA North in Sudan. You have the PKK, the LTTE, and so on and so forth. Paramilitary groups or militias. You have these types of actors much more active in Africa and in some Latin American conflict, like in Colombia. You have so-called terrorist groups, which is not a terminology that I like, but those are armed groups that spread panic and fear in societies in order to achieve political goals, like, of course, the Islamic State or Al-Qaeda. And, groups like the Islamic State or Al-Qaeda can also have characteristics of those different elements. So they can be at the same time armed opposition groups and be considered as terrorist groups. So it's not all these elements are not mutually, let's say, exclusive, right? So you can have elements of these in one armed group. It's just a way to understand better what these actors might be. And then, as I told you, you have vigilante or self-defense groups, which are not very much organized, which do not have a clear ideology or do not have the intention to topple a government or to have their own autonomy in a region, but rather are there just to defend themselves. And then you have what we call territorial gangs, armed gangs, like in Mexico or in arguably in other states, that can also qualify as non-state armed groups under international humanitarian law. Having looked at what is a non-state armed group, how we can understand these actors, the next step is to look at the applicable law. And here you have to understand that there was a big evolution in the drafting of these norms and how these actors were bound or were considered bound by international humanitarian law. The first, let's say, provision that we see is in international humanitarian law is Common Article 3. And I will like you to look at now the different obligations that you find in this article with regard to the scope of protection. The history of Common Article 3, as I told you in the preceding classes, is that usually, historically, conflicts were considered to be conflicts between states, international conflicts. And the four Geneva Conventions really addressed these types of conflicts, how states, were bound by certain obligations in situation of armed conflict, opposing them to other states. In the 1930s, there was the Spanish Civil War, and to address the Spanish Civil War, it was considered important to also include an article on non-international conflict in the Geneva Conventions, and here you find Common Article 3. You'll see Common Article 3 is very short. It's considered as the basis of what has given birth to a more broader, let's say, normative framework applicable to non-international conflict. But during, between 1949 until the second additional protocol of 1977, there was very few norms applicable in this type of conflicts. And it was also due to the approach that the international community had with regard to what was happening within their own frontiers. You had, in parallel, the evolution of human rights law, But the first two conventions of human rights law were only drafted also in 1966 and came into force a decade later. So in the head, for many states, what was considered important is their own sovereignty, and whatever was happening within their own borders was not considered to be a matter of concern for the international community. And this is very clear also, this is very clearly stated in the UN Charter. Article 2 of the UN Charter says that, whatever happens within frontier is of the domaine réservé of a state. It is a matter of its own concern. This has evolved over times, and it has evolved not only from the human rights side, because under human rights law now it is clearly considered that serious violations of human rights or massive violation of human rights is also of concern of the international community. And the proof is that the UN Security Council has adopted many resolutions on the commission of human rights violations. And it is also considered to be a matter of international humanitarian law. And international humanitarian law also regulates the behavior of non-state actors which are active within the border of a state. So this is the whole purpose of NIAC. So Common Article 3 is the first step where you have to look into to see what norms are applicable in this kind of situation. One thing I'd like you to consider is that in Common Article 3, those are all norms in relation rather to treatment or protection of the person. So you have the prohibition, of course, of murder or to torture someone in detention or those who have laid down their arms. You have also the obligation to respect certain fair trial principles when there are trials being conducted. You have the obligation to take care of the wounded and sick, also in non-international conflict. But really, you don't have much indication of means and methods of warfare, principle of distinction, the use of weapons. This we are going to look into more in detail, and we will find these obligations in other norms, but not in Common Article 3. So we will find this obligation notably first in Protocol Additional 2, which contains a norm protecting civilians, but also, as we will see, in customary international law. So now coming to Protocol Additional 2, which was drafted much later than Common Article 3, contains more provision than what you can find in Common Article 3. Although here too, I would like again to ask you to look at the different norms which you will find in the Protocol 2. And you will see that there are only about 20 norms, right? And this, when you compare with what you can find in Protocol Additional 1, which is applicable in international armed conflict, and in the Geneva Conventions, you will see a big imbalance between the volume of the obligations between international armed conflict and non-international armed conflict. And this can be understood, why this difference can be understood, because again, states did not want to have the international community looking too much into what was happening within their own borders. This also explains the higher threshold that you will find of application that you will find in Protocol Additional 2 rather than in Common Article 3. If we come back to Common Article 3, and now I'm coming back to this, you'll see that it says just in the case of armed conflict, not of an international character. This is in the preamble or in the chapeau rather of Common Article 3. Now coming back to Protocol Additional 2, you'll see that there are much more conditions. So the first condition is that the rules contained in AP2 apply to armed conflict which take place on the territory of a party. between its armed forces and dissident armed forces or other organized armed groups. So, Protocol Additional 2 only applies to a state when fighting to a non-state armed group or to several other non-state armed groups. So this is a first difference with Common Article 3, because Common Article 3 does not limit its application to the combat, to the armed violence between a state and non-state armed group. It also applies, therefore, to the use of armed force or to combat between armed groups. And so here, for example, the combat that took place in Syria between the Kurdish armed groups and the Islamic State would be regulated by Common Article 3, but not by Protocol Additional 2, provided, of course, that Syria would have ratified the protocol, which it did not have. But so in that case, this is one of the first difference. The second difference between Common Article 3 and Protocol Additional 2 is that armed groups must control a part of the state territory. And this again requires a higher degree of organization of the armed groups to be able to control territory, and will not apply to those armed groups that do not control territory. So Additional Protocol 2 will apply in limited circumstances involving armed groups, where Common Article 3 will apply more broadly. But one of the issues, as I said before, is that you'll find, at least in treaty law, only a few norms applicable, only a few norms in the actual text of Common Article 3, whereas you have a bit more norms applicable in Protocol Additional 2. That also, you need to keep in mind that not all states have ratified Protocol Additional 2. So it means that, again, here, this treaty will not be universally applied in case of a non-international armed conflict. So this is why it's very important and crucial to look at customary international humanitarian law. The ICRC study done in conjunction with Cambridge University Press has also highlighted that there was, the majority of, or at least many rules which were applicable in international armed conflict under customary international law was also applicable in non-international armed conflict. And so this is very important, because when you look at the rules that are highlighted in this study, and here I'd like you to look at the website of the customary international humanitarian law project that you'll find on the ICRC website, and you have this on your material. You'll see that there are rules concerning, for example, conduct of hostilities, the use of weapons, norms that you will not find ipso facto in treaty law, and notably in Common Article 3, which is, which concerns only certain type of rules and not conduct of hostility rules, for example. And this evolution has been done thanks to case law again, where in the Tadic case, for example, in the ICTY, it was considered that many of the behavior which was prohibited by states, for states rather, in international armed conflict had also, by logic, to be prohibited to a conflict that would take place within a state border. And all of this is to be appreciated in the light of the fact that today the majority of armed conflicts are non-international armed conflicts. So it's very important to understand what are the norms regulating this type of conflicts, because if you only think that it's the few treaty norms that are applicable in this type of conflicts, then you will find yourself quite limited in the regulation of these actors. But this is not the case. As I told you, you have Common Article 3, Protocol Additional 2 in certain circumstances, and customary international humanitarian law, which is applicable to all armed conflicts considered to be non-international armed conflicts, between the conflict between armed groups and whether or not they are controlling territory or fighting directly the state. I won't go too much into the detail here, but just to tell you that how customary international law actually applies to armed groups has been a discussion, a long discussion among scholars, but also was addressed to a certain extent by some tribunals. I will not go too much here into the detail. If you're interested in this, you can look at an article which is quite interesting, written by Sandesh Sivakumaran, Binding Armed Opposition Groups, which explains the different theories that have been elaborated to explain why armed groups are also bound by international humanitarian law. Finally, I just wanted to discuss briefly the application of human rights law in situation of non-international armed conflict, and in particular to non-state armed groups. This is a very controversial topic. It is not disputed that human rights law is applicable in international armed conflict, but also in non-international armed conflict to states, right? Here, I mean, there has been, as we have seen in our course, there has been some state which discusses, or at least are not fully in agreement with the case law or some scholars about the application of human rights law in armed conflict situation in general. But the majority of the scholarship and the case law and different organizations do believe that human rights law is applicable in armed conflict situation to states. What is controversial is what is more controversial is to what extent human rights law applies to non-state armed groups. And it's controversial for different reasons also among scholars, because some scholars believe that human rights law is not really appropriate as a body of law to bind armed groups, because human rights law would be about the relationship between an individual living under the jurisdiction of a state and the state. So I cannot go at this stage in the detail of this discussion, but the different, humanitarian organizations, but also international organizations, and I'm thinking in particular at the United Nations and different monitoring mechanisms at the United Nations, have expressed their concern about the fact that some armed groups which control territory, and sometimes large portion of territory and population, would not be bound by human rights law and only by international humanitarian law. Normatively speaking, it can create some issues, for example, with regard to respect of freedom of expression, which is not regulated by IHL but only by human rights law, or simply everyday life matters that would be better regulated by human rights law rather than IHL. And so there is, let's say, a trend, or not a trend, but an emerging, let's say, I'm still reticent to talk about consensus, but an emerging common thought that human rights law might be applicable to de facto entities that de facto control a territory, de facto authorities. So that those authorities would be non-state in character, but would, perform acts which usually are performed by state authorities. I'm back for the third part of the course. I'm sorry I had to cut before. So we have seen so far the two first part of this course was about how to define armed non-state actors, what is an armed non-state actors, and we have seen that there are different types of these kind of actors that can go from very highly organized armed groups to less organized armed groups. We have also seen that in order for the law of non-international armed conflict to apply, you need to have indeed a certain level of organization of the armed groups and also protracted armed violence. And this is what you have seen in the classification of armed conflict course 2 or 3 weeks ago. Now, what is important is also to address within this course the policy issues surrounding non-international armed conflict and the engagement of armed non-state actors. As we have seen, the majority of armed conflicts today are non-international armed conflict, and the international community has asked us several times that it was important also to engage these actors in order for a better application of IHL to better protect the civilian population that live in situation of armed non-state actors. And there are different organizations that engage with armed non-state actors, and I'm going to highlight what are how we can engage these actors and what are the challenges in engaging them. So here just a paragraph of the report on the protection of civilians by the United Nations Secretary General in 2009, which I found interesting, but you have to keep in mind that this call for engagement has been done on a regular basis by the UNSG. So the UNSG just, says that improve compliance with IHL and human rights, the call for improved compliance will always remain a distant prospect in the absence of the need for consistent engagement with non-state armed groups. So in a nutshell, what he says is that if the international community wants to improve compliance with international humanitarian law, there is a need also to engage armed non-state actors, which are the majority of actors today, in a better respect for IHL. Because otherwise you just forget, you put aside the majority of the relevant actors and states, engaging states themselves, only states themselves is not enough in that endeavor. One of the questions that we may ask is, what does it mean? What do we mean by engagement? What is engagement? So there is no precise definition, and one can say that engagement is to raise awareness about the applicable law in non-international armed conflict. Many armed groups do not exactly know what they are bound by, do not exactly know the rules. So awareness raising is a form of engagement for IHL. The same goes with dissemination, which is close also, the fact to disseminate the applicable rules, what does Common Article 3 says, how, for example, is the UN Security Council operates with armed non-state actors, what are the consequences of this, is also important, a tool of dissemination. Persuasion is a form of engagement of armed non-state actors. And also perhaps a bit more complicated is technical support and capacity building. And this is a form of engagement which will be very difficult for political reasons for many international organizations such as the UN, for example, to engage in terms of capacity building with armed non-state actors is something that they will not be able to do usually, because states will be very reluctant to allow international organizations to enhance the capacity of armed non-state actors when these actors are in fact, fighting states. And it doesn't mean it doesn't, capacity building does not necessarily mean, giving more resources to unarmed non-state actors. But if one can think about to enhance the capacity of unarmed non-state actors, for example, to conduct forensic operation, this would already in itself be complicated. Or, for example, to train the military force, to train them in human rights, on law enforcement and on this type of issues, can also be interpreted as capacity building, and can also be complicated for international organization to do. So what you will see is that it will rather be NGOs, non-governmental organization, which will engage in capacity building, or not even capacity building, but will try to, for example, allow unarmed non-state armed groups to demine certain fields. So demining organization, we can interpret this as a capacity building form of engagement, and this usually will be done by other NGOs, which are less susceptible to be under pressure by states to do this kind of works than the United Nations would be, for example. Engagement can also mean negotiation, dialogue, advocacy. All these forms of engagement are indeed necessary to convince unarmed non-state actors that it is in its own interest also to respect IHL for different reasons. So what could be the reasons why unarmed non-state actors would not respect IHL? So there are many, of course, in political science, in behavioral science, there are many reasons why a certain actor would not respect the law. With regard to non-state actors, research has highlighted that there might be reasons pertaining to, for example, strategic military concerns. Because in an armed conflict, usually armed non-state actors have less means to conduct a conflict, to conduct the war. They will tend to take advantage of, for example, hiding in urban centers in order to be able to conduct, for example, guerrilla warfares, or a strategy that would allow them to not have recourses to heavy or financial to means to conduct the war, which would require very high level of sophistication or financial capacity. So strategic military concerns can also attract the fact that because armed groups would hide in cities, for example, or would take advantage of this kind of environment, would attract a reaction by states, which would make it more difficult for them to actually respect certain IHL norms. So that would be considered as one of the reasons why IHL would not be respected in certain contexts. Then you would have the fact that in a non-international armed conflict, combatants are not protected by the rules that allow a soldier, for example, to take arms against an enemy state. So, for example, you cannot try criminally someone who has been called by his state to participate in an armed conflict against another state. Because it is illegal for a group of persons to take arms against its own government and to use force within against other civilian or the government, the law of non-international armed conflict does not grant combatant immunity to members of armed groups. And this might be one of the reasons that armed groups feel that because they can be arrested by their state and put, for example, under a harsh sanction as one of the death penalty, they have nothing to lose, and they don't have any advantage in respecting IHL norms. So that would be one of the reasons why in certain circumstances IHL norms would not be respected, because in fact it doesn't give so much incentive for the armed groups to respect these norms, since they can be arrested anyhow for having participated in hostilities. There are some rules in IHL that require states, there is a rule that requires states, for example, whenever it's possible, to grant amnesties for the mere fact of having participated in hostilities, in order to ensure that there is some kind of incentive for members of armed groups to respect certain norms of IHL. And that was one of the reasons why this encouragement to grant amnesties for the mere fact of having participated in hostilities, but of course not for having committed war crimes or crimes against humanities, was inserted in the protocol. Another reason why armed non-state actor might be prevented or do not respect IHL is the lack of knowledge of international norms. And IHL is quite sophisticated. Look, I'm teaching you now for 24 hours what are the basic rules of IHL, and it's already quite challenging for us. You can just imagine that for members of armed groups, which do not necessarily all have, access to some who did not have access to a certain level of education, or that have lived most of their life in a combat zone, would know of these rules. So the lack of knowledge of international norms is also one of the reasons that some armed groups, at least, might not respect certain norms. Although this is less and less the case today, because many armed groups have quite I wouldn't say a sophisticated level of knowledge of IHL, but at least of the basic rules. And we'll see that in a while. There is also the fact that in some circumstances, the ideology of the armed groups might lead to the violation of certain norms. And here I would encourage you to look for the article of Olivier Bangerter, who wrote in the International Review of the Red Cross a very interesting article, which is called Reasons why armed groups decide to respect or not international humanitarian law. This is an article which highlights, and it's very interesting, it highlights why IHL is not respected in certain cases. And he gives example of certain armed groups, not only jihadist armed groups, but for example, the LRA, which uses certain strategy, knowingly violating IHL norms in order to put not only pressure to the adversary, but also to use terror as a strategy, in fact, to win the war. So the ideology might lead indeed to violating certain norms. And finally, there is this argument of lack of ownership. And by lack of ownership, leading to the violation of IHL goes in that way. Armed non-state actors do not have the possibility to negotiate international instruments because they are not, subject of international law. They do not participate in conferences that lead to the adoption of these norms. So they might feel that this is not a body of norms that concern them, that it's not for them. It's for states and not for them. And also the way that certain norms are formulated really apply to states and not to the particular structure of armed non-state actors. And there is some truth in these arguments. there are some norms that will be particularly difficult to apply for armed non-state actors. And here, a classic example is the norm which you can find in Common Article 3, which requires armed non-state actors to conduct a trial according to fair trial principles. And fair trial principles are the ones that, usually are applied in courts in certain, in states, which states have this obligation under human rights law to provide for procedural protection of a very high level. How to apply this to armed groups is a matter of discussion. And that might be an example of how the lack of participation of armed groups in certain elaboration of certain norms might be problematic. Now, what are the incentives, or in other words, what would push an armed group to respect IHL? And here also we can mention few incentives. First of all, the need for popular support, or in other words, in military terminology, winning hearts and minds of the population. It is clear that, and there has been studies about this, that an armed group will have difficulty to win a conflict or even a state if it entirely lacks the support of its constituency. And if an armed group behaves in a way that it terrorizes the civilian population or it loses its grassroots support, will at the end of the day, would rather prefer respecting the norms that protects its own population or its own constituency. So the need for popular support, including of its own constituency, but also, of the diaspora, will be a strong incentive. The second incentive that we can mention is the group's own internal belief. And many armed groups actually fight, and in order also to be able to recruit members, are building their fight under, for example, human rights arguments, or arguments which are based on religious beliefs that are not contrary to what IHL promotes. For example, the respect for civilian life, the respect of the prohibition of torture, and so on and so forth. So in many circumstances, armed groups do have internal codes of conduct and internal beliefs that are built on different principles that are not necessarily contrary to IHL. One of the main incentives that many armed groups are, and that makes states very nervous, is of course the seek of legitimacy. Armed groups seek legitimacy to have a good image, because this good image will allow them to be invited, for example, at the negotiation table, would allow them to have access to certain resources to continue their fight. So the quest for legitimacy, which is also close for the need for popular support, is a strong incentive to respect IHL and to be perceived as a better actor, for example, than the state that they are fighting. And this is an argument that comes a lot in the discussion when you talk to armed groups. The avoidance of criminal sanction is a very powerful also incentive for armed groups to respect certain norms. Armed groups are aware now that the International Criminal Court or even universal jurisdiction can be a mean to hold certain members of armed groups as responsible for war crimes, crimes against humanity, or even sometimes genocide. So armed groups will ensure that they try their best to avoid criminal sanction, and that can be an incentive for them to respect the rules. Finally, and I think that should not be underestimated, armed groups can also desire to behave in a humanitarian way. And organizations such as Geneva Call, which engage in armed groups on different thematic, has also, in their own work, highlighted the fact that armed groups do not want necessarily to act contrary to IHL norms, and that generally they really want to also behave in a humanitarian way. Of course, you have to keep in mind what we have talked at the beginning of this course, that there are different kinds of armed non-state actors, and that we cannot put all the armed groups in the same box, and everything needs to be done on a on a case-by-case approach. But understanding what is the ideology of a group, understanding how the group has behaved, understanding its military strategy or other strategy is an essential step before engaging any kind of armed non-state actors. And certain armed non-state actors, armed groups, will be beyond engagement at a certain point of time, because you can also have an evolution over time of how an armed group is open to the discussion about certain IHL norms or international law in general. With regard to this example that armed groups also want to behave on a certain way, I would like to show you this image, which won the press award of 2016, which shows a doctor or a nurse belonging to the PKK healing a fighter for the Islamic State, and this is in conformity of IHL rules and human rights rules, to treat the wounded and sick, and but one can really wonder, what is the motivation behind this doctor? Is it really a motivation to respect IHL, or is it a human motivation just to behave humanly? I mean, and I think that we would rather lean towards the second explanation. So it is good that in that sense, I mean, IHL norms and the principle of humanity converge to the same objective. But when we look at the motivation of armed groups, we also have to take this into account. How do we engage armed groups? There are several means. There are several organizations that do so. So the well-known organization on engaging armed groups is Geneva Call. If we are managing to organize a visit to Geneva, which I'm not sure we will be able to, but this is one of the organizations I wanted you to visit. You can look on their website what they are doing. It's a great NGO. They convince armed groups to sign deed of commitments. That's how they call. There are different deeds of commitments on different themes, on children in armed conflicts, on sexual violence, on the provision of healthcare, humanitarian access, and on demining. And these codes of conduct mirrors, in fact, the commitment that states have made under international treaties. So, of course, these are unilateral declarations. They are not per se binding legally, but they are also a way that armed groups own the whole process. And the Geneva Call deed of commitments are signed, for example, in a very official way, which tells in a nutshell to the armed groups, now you are responsible, you have engaged yourself in respecting those norms, and you will be held to this engagement. And it's symbolic, but symbolic can also be quite effective. There is also the possibility to negotiate and sign with armed groups special agreements. This is foreseen in Common Article 3 in paragraph 2. There are also articles written about this. Special agreements are signed between parties to the armed conflict, and they say that they might say, for example, that the whole body of the law applicable in international armed conflict can be applicable to the fight to the situation that the armed group is facing, for example, in non-international armed conflicts. So special agreements are also a means to engage the armed groups. I would like also to talk about action plans. Action plans are a special type of engagement which is done by UNICEF, which engages armed groups in the delisting, or actually pushes armed groups not to use children in hostilities, and by children it's children which are below 18 years old and not 15 years old, so the threshold is quite high. I also encourage you to look at this at the website of UNICEF and try to look how the action plans are working in practice. It's quite interesting also process. One can wonder if there are impacts, positive impacts on engaging with armed groups. And here I'm showing you a picture which is a picture of Geneva Code that shows that these children, in the context of the Kurdish conflict in northern Syria, were all dressed in military attire. And by being dressed in the military clothes, it makes them quite clear that they are military objectives. And one way also to encourage an armed group not to use children in armed hostility, which is a war crime, is also to ensure that they do not become military objectives. So that was one of the recommendation that Geneva Code did to the armed group is you should dress these children in civilian clothes. And here, the next slide, you see the kids that were indeed clothes in civilian clothes, and that they were playing in the field rather than being perceived as as members of the armed group. So here you can see a clear before and after engagement process with an armed group that has bear some fruit. Now, for the last session, I wanted also on this course on the law of non-international armed conflict and the challenges that armed groups represent, I wanted to finish indeed by the challenges, contemporary challenges that we are facing in not only apply the law, but also in engaging the groups. I found this this quote by Christopher Clapham in a book that he wrote on armed groups in Africa that was pretty much highlighting some of the key challenges. So in this quote, Christopher Clapham says the African continent is left with a plethora of movements, for the most part locked into regional patterns of conflict, which generally suffer from weak internal organization and poorly articulated goals, and can be far less readily incorporated into stable political settlements than earlier liberation insurgencies and reform insurgencies. What he says is that, at least in Africa, we have different groups, like a plethora of armed groups with different structures, and those structures are such that it's going to be difficult to engage with them and to ensure that these armed groups respect the norms because of their weak organizational structure. So among these challenges, you have, of course, the multiplicity and fragmentation of the groups, which renders difficult the establishment of the responsibility and accountability procedures. in the Syrian conflict, at least in the beginning of the Syrian conflict in 2012 and 13, we would count more than 1,000 armed groups active in the zone. The same goes with regard to Libya and to other contexts where you have different armed groups which are of different structure, of different ideologies, and then which can also become fragmented. This makes difficult the application of the law, and as a consequence will also make difficult the responsibility when war crimes are committed. This multiplicity of armed groups also makes it difficult to devise standardized approaches to engagement with armed groups. I've get cut another time, sorry. There seems to be a problem of compatibility with this application and my computer, so hopefully I'll be able to finish this course. I was cut at the point where I was talking to you about the different ideologies that can lead to the violations of the norms, and this is one of the challenges that we see today. And of course, it's not only armed groups that have particular ideologies, but state can also have them. The debate arose when there were armed groups such as the Islamic State or Al-Qaeda. So there was a lot of debate with regard to jihadist armed groups and the way they interpreted their particular faith that was incompatible with some of the norms of IHL and human rights law. But it was, of course, their own ideologies. But I wanted to also flag that there exist other types of ideologies that can lead to the violations of IHL and which can, for example, focus more on certain practice than others, and which would be incompatible with certain human rights or IHL norms. But that is just one of the challenges that we can witness. There are also operational challenges, and by operational challenges, I'm thinking about what we have called transnational violence, meaning that in certain states the conflict spreads across frontiers, which makes it more difficult again to apply certain norms and to hold certain actors as responsible. And that would be indeed one of the operational challenges. Another one would be the absence of state infrastructure, which renders difficult the establishment of control in certain zones, leaving the control to armed groups that in their turn are not able perhaps to implement certain norms. And one of the final challenge that we have witnessed together, that we have already talked about, is the fact that today conflicts are more and more protracted, last over years, and so it means that the law of non-international conflict remains applicable in a long period of time, and that armed groups evolve over the time as well, and it's difficult to have some kind of permanent or let's say more stable situation which would allow first to engage with these actors and to devise strategies of peace, or the strategies allowing for a better protection of civilians. Another complicated issue about the fact that non-international armed conflict are the most prevalent one, and the fact that we have this multiplicity of armed groups, is the uncertainty with regard to the legal framework. I have told you at the beginning of the course that there was a big challenge, or at least a big controversy with regard to the applicability of human rights law to armed non-state actors. And this, for NGOs, might create a problem. Here we have a paragraph of an analysis of the work of NGOs in Nepal, which shows that the fact that there was a lack of a clear legal framework applicable in certain situations would create monitoring issues for these NGOs. So the lack of the legal framework applicable to armed non-state actors, or the blurring of certain legal framework, is also one of the clear challenge that humanitarian NGOs or human rights NGOs might face. Finally, there is this the problem of the application of counterterrorism measures to armed non-state actors. I will not go too much into the detail because we are going to have a course on this. But just to tell you in a nutshell that the problem of applying counterterrorism measures or terminology to armed groups creates confusion because it does not rightfully distinguish between the lawful acts of war, which respect, for example, the principle of distinction, and acts of terrorism, which does not respect IHL. And you may find armed groups that actually respect, in certain circumstances, IHL, but which are still considered to be terrorist armed groups by certain states. And that would push them not to respect the norms, because whatever they do, they will be labeled as a terrorist armed groups. So it's this is not the determination as all armed groups as terrorists, irrespective of their compliance with international norms, is not conducive to promoting respect for IHL or dialogue. And it is also important to consider that armed non-state actors are not only, armed groups that are, as perpetrators of violations of international law, but sometimes armed groups can be a promoter of international humanitarian law and can be partners in the implementation of certain norms. And to illustrate this, I wanted to show you the last slide of this course, which shows how an armed group has helped the evacuation of a refugee camp in a certain conflict, and that was in Mount Sinjar. So in certain cases where states cannot necessarily be involved, there are the possibilities that armed groups can be a partner in the implementation of international humanitarian law and in the promotion of the protection of civilians in armed conflict. So with this, I'm finishing this lecture on the law of non-international armed conflict. In summary, I would like you to go back to the different provisions that apply in non-international armed conflict, so Common Article 3, and read also the provisions in Protocol Additional 2, keeping in mind the conditions of applicability of these treaties, and the fact that customary international humanitarian law also applies to armed non-state actors. You'll have to understand that there are difficulties in determining certain armed groups as being armed groups, because they need to reach a certain level of organization in order to be bound by IHL. We have also seen that there are challenges with regard to the existence of armed groups today, and that engaging armed groups on the promotion of international humanitarian law might also be challenging, even if it is necessary. So keep tuned, and I'll come back with our next course on counterterrorism and armed non-state actors. Bye.